Well, good morning and welcome. It's lovely to have you with us. Thanks very much for joining us. We're just hanging on to see if one or two more people join us, but I think we'll start within the next minute or so. Just whilst we're waiting to see if any more join us, I'll just briefly introduce myself. I'm Doug Mullen. I'm a senior associate in our pensions and employment team. So I lead a team providing advice on the LGPS and public sector schemes, and in particular pension disputes under the internal dispute resolution procedure. Okay, well, we're going to have a look at the outline of the process for dealing with disputes today under the local government pension scheme regulations, and also look at some practical tips for dealing with disputes, and also along the way how you might look to avoid some common disputes. So the background is that each scheme has got to have its own internal dispute resolution procedure, and that doesn't just apply to the local government pension scheme. That's something that all occupational schemes need to have under Section 50 of the Pensions Act 1995. The LGPS has gone one step further and has actually set out the procedure within the regulations governing the LGPS. So regulations 74 to 77 of the 2013 regulations. Other occupational schemes typically set their own procedure. It won't be in their scheme rules, but the LGPS has decided that it'll set it out within the regulations. So what's the internal dispute resolution procedure for? Well, if you're familiar with the employment context, it's a bit like a grievance. It's an opportunity for members or those connected with members to raise complaints about decisions taken by employers or the scheme administrators. Like a grievance, it's a two-stage process, so initial complaint, but also the opportunity for a second stage appeal in effect. So why does this matter? Why should you be bothered about the internal dispute resolution procedure? Well, as part of the regulations, obviously it's a part of the law, so something you need to comply with. But more than that, there's been a steady increase in the number of references being made to the Pensions Ombudsman. So the Pensions Ombudsman has the power to deal with complaints about occupational pensions. The number of complaints has been rising pretty steadily over the last 4 years. So there's been a growth of about 50% in new complaints over the last 4 years, including, in fact, 20% in the last reported year. The Pensions Ombudsman has the power not just to make decisions on complaints, but also to award compensation. And in broad terms, that takes two formats: compensation for financial loss, but also compensation for non-financial loss, which can include distress caused to members or their those who are connected with members. So there is not just a bark, but also a bite to the Pensions Ombudsman. Well, let's have a look at some of the typical disputes that we see. When we're dealing with disputes, commonly we see a lot of ill health retirement decisions being challenged, and that's perhaps not surprising really, because Ill health retirement benefits under the local government pension scheme are pretty generous and costly for employers, and we therefore see quite a lot of complaints about requests for ill health retirement or early release of pension benefits on ill health grounds. Where those requests have been rejected, we often see complaints. Death in service is something that we also see complaints around. So typically that tends to be where an employer or scheme administrator has not dealt with some request, perhaps a transfer request, quickly enough. Another area that is ripe for dispute is discretionary benefits. So employers in the local government pension scheme have the power to award certain discretionary benefits. So that might be the award of additional pension, or it might mean the waiver of an actuarial reduction to an early retirement pension. And again, these additional benefits can be quite valuable for members. And so perhaps unsurprisingly, where discretionary benefits are refused, you will often see complaints about these. And redundancy or business efficiency dismissals, again, where members, active members, are aged at least 55 and have 2 years service, then if made redundant or their employment ends on business efficiency grounds, they're entitled to immediate access to their pension benefits on an unreduced basis. That can be costly for employers. There may be an additional strain cost to pay, and so we often see disputes around whether there is or isn't a redundancy situation. For scheme administrators, so administering authorities, we see complaints about overpayments and benefit calculations, sometimes around transfers as well, transfers out of the scheme. So which decisions can be dealt with under the internal dispute resolution procedure? Well, any first instance decision, so that's any initial decision about people's rights or about liabilities, so contributions they might be liable to pay under the scheme. People can also complain about any other act or omission of an administering authority. Okay, so who's responsible for what decisions? Well, the administering authority is responsible for decisions about a member's previous service or employment. They're responsible for decisions about how much additional pension someone will be entitled to if they purchase additional pension under Regulation 16. They're also more generally responsible for decisions about the amount of benefits that a member's entitled to, or where there's a refund of contributions, the amount of that refund. Scheme employers decide on pretty much everything else. So that could range from whether an employee is eligible to join the scheme, what their pensionable pay is, what the member contribution rate is, whether they're entitled to benefits on termination, or whether they're entitled to early release of benefits if they leave before normal pension age. So lots of things that employers are responsible for. In particular, they are, as I've already mentioned, responsible for discretionary benefits. So there are certain discretions that they have. Employers are expected to have a policy on how they will exercise their discretions. So within 3 months of joining the scheme, an employer is supposed to put in place a policy covering certain discretions and to provide a copy of that to the administering authority. Just to say, if you have any questions, there is an option to ask questions. So if you expand the control panel, which you should see on the right-hand side of your screen, you expand it by clicking on the little orange arrow, and further down towards the bottom of the control panel, you should see in a grey box, questions, and there's if you click on that, that should give you a space to type in questions. I'm going to deal with questions at the end of the session, so please do type them in as you go along, but I won't deal with them until the end of the session. Okay, so let's imagine that you're an employee, you've made a decision. What do you need to tell? What do you need to tell the member? Well, where you have made a decision that affects a member's benefits, so a first instance decision about their benefits or rights or liabilities under the scheme, you need to provide a written notification of that decision. Where you've refused a benefit, or if you're a scheme administrator, so the administering authority, where you've calculated a member's benefit, then you also need to set out the reasons for refusing the benefit, or where you've provided the amount of a benefit, the basis of calculation. You don't have to do that if a benefit is granted, so no need to state reasons there. But if you refuse a benefit or calculate a benefit, you need to provide reasons or a basis of calculation. You also need to give members an address for further information. So if they want to know more, you need to give them details of how they can contact someone to get further information. Importantly, you also need to inform them of the two-stage internal dispute resolution procedure. So every time you provide a written decision notification, you need to refer to the dispute resolution procedure. You need to give it the deadline for them raising a dispute, and you also need to give the address and job title of the person who they can raise a dispute with. I think our experience is that administering authorities are fairly good at doing this. So you would typically see on benefit calculations that there will be details provided of who disputes should be raised with and deadlines for doing so. I think it's something that scheme employers are less aware of. So, for instance, when a scheme employer makes a discretionary decision, so let's say there's a decision not to award a discretionary benefit, so not to grant additional pension on making someone redundant, then that decision should be notified to the member and they should be given details of the dispute resolution procedure. I can perhaps hear many scheme employers thinking, well, that's just going to potentially provoke a lot more disputes. You may well be right about that, but you do need to be aware that your obligation is to notify the decision in writing and to provide details of the dispute resolution procedure. So what are the deadlines then for raising disputes? We've just said that these need to be notified. Well, for an initial decision, someone has 6 months from the notification, so the written notification of that decision, or of the act or omission that they're complaining about, 6 months in which to raise a complaint. Now, that time limit can be extended at the discretion of the first stage adjudicator. I do think it's worth just being aware of time limits, because the first stage adjudication is to be carried out by someone appointed by the employer, so the scheme employer, and we do sometimes see some decisions which have been appealed out of time, and there doesn't seem to have been any consideration of whether that complaint should be dealt with or not. Now, it may be that actually the decision has just been taken to deal with it anyway, because of the risk of a complaint being made to the Pensions Ombudsman. But it is worth being aware that if matters or complaints are substantially out of time, there is that option to reject a complaint on the basis that it's out of time. So let's say someone is making an application for their complaint to be heard. What do they need to provide? Well, it's fairly straightforward. They need to provide their name, their address, their date of birth. If they're not a member, then they also need to provide their national insurance number. They need to set out basically why they disagree with the decision or the reason why they're aggrieved. They need to give you a copy of the original decision, and their application needs to be signed either by them or on behalf of the person making that complaint. Where they're not a member, they also need to set out the nature of their relationship to the member. So, for instance, it might be that they say, well, I'm the husband or the wife of the member, or a child of the member, for instance. And it may be that they're complaining about perhaps the failure to provide death in service benefits. Okay, so let's say that you don't get all of the information that they ought to provide. Should you just reject the complaint out of hand? Well, no, I don't think that would be wise. I think you should be asking for the additional information that you need in order to deal with the complaint. Of course, ultimately, if they're not providing information that is relevant to the dispute, then and to the complaint, then it may be that you're unable to reach a decision, or that your ability to investigate the complaint is pretty limited. So let's assume for a moment that a complaint has been received at the first stage by the scheme employer. So that the scheme employer is responsible for appointing an adjudicator to deal with first stage complaints. So it's probably helpful for scheme employers to do that in advance of any complaints being received, and it may also be helpful to notify who that person is to the administering authority as well, because sometimes complaints come in via the administering authority. It may also be helpful to have a couple of people appointed, just in case there's a conflict of interest for one of the people. So what sort of procedure does an adjudicator need to follow? Well, they've got quite a lot of discretion, so they can really set their own procedure. So an adjudicator can be advised, they can appoint others to investigate the circumstances and come back to them with their investigation findings, in much the same way that someone chairing a grievance might appoint someone to investigate the circumstances and then to bring their investigation report to the chair for a decision. It's also entirely up to the adjudicator whether they deal with a complaint on paper or whether they have an in-person meeting to discuss the complaint. Our experience is that typically complaints tend to be dealt with on paper rather than in person. But it really depends what's helpful in the circumstances. So once the complaint's been investigated and a decision has been made, what needs to happen next? Well, there's a need for a decision to be given in writing, and that decision needs to be copied to the person who made the complaint, the applicant. It also needs to be copied to the scheme employer, and the administering authority also needs a copy of that decision. And that needs to be provided, normally speaking, within 2 months of receiving the complaint or application. 2 months might seem like quite a long time, but actually it can be quite a short time if there's a lot of investigation to do. So there is also provision for extending. So you can extend by giving reasons for the delay in reaching a decision, and also an expected date for a decision. So an example of where very often we see there is a need to delay is in ill health retirement complaints. Very often it's necessary to get hold of medical records in order to make a decision, and that can take some time to get hold of. So our experience is that very often longer than 2 months will be needed in order to deal with an ill health retirement complaint. So what must the decision include? Well, you obviously got to say what decision has been reached, so that's a statement of the decision. You need to set out the legislation that has been relied upon, so the law that has been relied upon. So that will mean going back to the relevant bit of the LGPS regulations and referring to that or copying that out. You also need to set out that there is a right to appeal, so a right to a second stage adjudication, and the time limit for applying. So you'll need to set that out, give details of who will carry out that second stage adjudication. So that second stage adjudication will be carried out by someone appointed by the administering authority. So you, before sending out the decision letter, you will probably need to check with the administering authority who second stage appeals should be sent to. And you also need to give contact details for the Money and Pension Service, who provide advice to members on their pension rights. Now, it's important to note that a decision of an adjudicator will, generally speaking, replace the original decision taken. There is an exception to that, and that is where there has been an exercise of a discretion. So let's say, for instance, an employer has decided not to exercise its discretion to pay for additional pension for a member. Because that's a discretionary decision, that decision can't be simply replaced. It needs to be referred back to the scheme employer if the appeal succeeds, to be taken again. Of course, if the decision on the discretion is confirmed, then there's no need to refer it back. So it is important to identify where a discretionary decision is being made. So that's what the regulations say must be included in a decision. It's also worth noting that the Pensions Ombudsman expects that reasons will be given, and those reasons need to be sufficient that someone can understand why their complaint has been rejected or why it has succeeded. Okay, so let's assume that the complainant is still unhappy after the first stage adjudication. They can then apply to have it determined by the second stage adjudicator, so effectively on appeal. It's very similar process to the first stage application. We could maybe just flick back a few slides. So basis of application, you still need to include name and address, date of birth, outline of disagreement and the reason why someone's aggrieved. It needs to be signed by or on behalf of the claimant. So very similar. A couple of differences. It must include both the original decision and the stage 1 decision. So at stage 1, you obviously only need to include the original decision. Here you need both decisions. Now there's a deadline, again, for making a complaint, and that's generally speaking 6 months from receipt of the stage 1 decision. What if no decision has been made? Well, if no decision has been made within 7 months of the expected decision date, then an appeal can be put in. Or if actually there's been no decision at all within 9 months after the application date. So in that case, you can move straight from stage 1 to stage 2. So what about the second stage decision? Again, very similar to the first stage. The key difference is that you must also give in your decision, your written decision, contact details for the pensions ombudsman. Because if the complainant is still unhappy after the second stage of decision, they have the right to apply to the pensions ombudsman. So how many people do actually go on to apply to the pensions ombudsman? Well, there were about 1,600 complaints made to the pensions ombudsman, new complaints, in 2017-2018, and about 30% of those were formally resolved by the pensions ombudsman. There's also an informal resolution process, so lots of those complaints will have been informally resolved. Right, well, let's talk about some practical tips for dealing with complaints. I think our key practical tip, rather like the motto of the Scouts, is to be prepared. Be prepared. So it must be pretty tempting to look at a complaint and to think, well, that looks really difficult. It's about pensions. I'm not very familiar with pensions. I'm going to put it in my metaphorical in tray, and I will save that for a rainy day. We would say that's not a good start. Grappling with the complaint early on is important for ensuring that you get the right information for making your decision. And very often you will need to get quite a bit of information, perhaps from the complainant, perhaps from the original decision maker, or if ill health retirement is the subject of the complaint, you may need to go to the complainant's doctor, medical specialists. You will also need, in those circumstances, to get a further medical opinion. So we would say early identification of what is the relevant law. So you need to know what the law is to find out what's the decision that's being made. Is it a discretionary decision? What process should have been followed? Who should make the decision? Again, it's important to identify who should have made the original decision. Often it's very clear, but sometimes it isn't. So with ill health retirements, one of the very frequent grounds for complaint is that the employer has simply left the decision up to the medical expert. They haven't engaged with the decision, they've just rubber stamped the opinion of the medical expert. Well, the pension scheme regulations are clear that it is the employer who needs to make the decision. So it may be that you identify really quite early on that actually there has been a failure for the right person to make the decision. Again, identifying whether it's a discretionary decision is also important, because employers making discretionary decisions have quite a bit of latitude in how they make their decisions, and it'll also be relevant in deciding what outcome should there be if the complaint is upheld. But the most important point is actually working out what information is needed to adjudicate on the dispute. So let's take an example of ill health retirement. So you need to identify the relevant regulations in the LGPS regulations, so that you're clear on what the test is that should have been applied. The test is that someone who is being retired on ill health grounds, if they're going to be eligible for benefits, they need to be permanently incapable of the duties of their role by reason of physical or mental ill health. And they also need to be incapable of gainful employment. Gainful employment is employment for at least 30 hours a week. And there are 3 tiers of benefits depending on how long someone is incapable of gainful employment. Well, just looking at that test, the immediate thing that strikes one is that medical evidence is going to be needed. So typically you would need to gather medical evidence from the complainant's general practitioner, any specialists that they visited. The regulations also make it clear that there is a need for an independent registered medical practitioner to have given an opinion before the initial decision was made. So there should have been also an opinion from an independent registered medical practitioner before any decision is made. So there's all that information that needs to be gathered before you can really start to assess whether an appropriate decision has been made. And as we've said, it can take really quite some time to gather that information. Sometimes you might get it quite quickly if it's already available, but sometimes it might take several months to get that. Okay, so let's assume that it's taking a little while to get this information. Another key thing is to keep complainants informed about the progress of their complaint. If you don't do that, you're likely to end up with further complaints. So do keep complainants informed. Some of them will be ringing you up on a very regular basis to find out what the latest progress is. But at the very least, you should be letting them know when you expect to make a decision. And if that time passes without you being able to make a decision, then you need to give them an updated decision date. Okay, so what about practical tips for making writing decisions. So a key thing when writing up your decision is to make it readable, make it understandable. If a complainant doesn't understand the decision reached, they are very likely to escalate their complaint. We typically recommend that the format of a decision letter should set out early on what the complaints were. So identify what the complaints were, give a brief summary of the decision reached in relation to those complaints, set out the relevant law, so refer to the relevant regulations and any pension ombudsman decisions, set out a summary of the relevant facts and deal with any dispute about the facts, so explain your conclusions on the facts and why you've reached them, and then explain why you have reached the decision that you have, which will generally involve applying the law to the factual situation. It's also worth checking whether there is any relevant guidance on the particular type of complaint that you're dealing with. So, for instance, the Department for Communities and Local Government, as it was, has produced guidance on ill health retirement, and that guidance is well worth having to hand when making a decision. Okay, well, we've reached the end of the formal bit of the presentation. There's an opportunity for questions. So let's see if there are any questions. If there are no questions yet, or if you have a question, then please do be typing it in. Just whilst we wait for questions, just to say that there are a number of different ways that we would be very happy to help you with dealing with disputes. So we can help investigate, we can help advise, we can provide training for adjudicators, we can help you with decision letters. We're also experienced in helping employers put together discretion policies. So let's now have a look at some of the complaints. Okay. So we've got one about whether we're going to be circulating the webinar afterwards. So yes, we will have the webinar available on our website. So the recording of the webinar will be available on our website. So people will be able to access it from our website. If you're not sure where to find it, then do get in touch with me or with the info address that's on this slide. So we've got another question here. Would a diagnosis of chronic fatigue syndrome be covered under ill health retirement? So the answer to that is possibly yes. Whether chronic fatigue meets the necessary tests will depend on its impact on the individual. So the fact that someone has chronic fatigue syndrome is not enough for them to be entitled to ill health retirement benefits. But if that means that they are permanently incapable of doing the duties of their current role, and if they are also incapable of gainful employment for at least 3 years, and gainful employment means employment for at least 30 hours a week, and that doesn't need to be the same employment or even similar employment. It's really any employment for at least 30 hours a week, then they will qualify. I should say that is under that's the test under the 2013 regulations. There are different tests under the different sets of regulations that have been in place over the years. So you do need to make sure you get the right test for the particular individual. Right, let's see what other questions we have. Okay, we've got quite a few here. There's quite a long one, which looks very specific, and I think that probably is something that you ought to take specific advice on. Whose liability is ill health retirement where specific enhancements apply? Is this the employer or the LGPS? So I think the question there is perhaps who makes the decision, but also who bears the cost. So the decision on ill health retirement is made by the employer, so the employer of the member. The only exception to that is if the employer is no longer participating in the local government pension scheme, in which case the decision would be made by the administering authority. In terms of cost, the cost will be borne of ill health retirement will be borne by the employer. Now, that may be funded in a couple of different ways. It may be that there will be an exceptional one-off strain contribution to be paid, or it may be that there is already a provision within the regular contribution rate to cover the cost of ill health retirements, typically up to a certain level. So there are a couple of different ways that it might be funded. Let's see. Can costs for engaging a solicitor or other specialist be reclaimed by an individual if the decision of the adjudicator is in favour of the individual? So the adjudicator doesn't have the power to award compensation. So neither first stage nor second stage adjudicators have the power to award compensation or costs. So the short answer to that is no. Very exceptionally, the Pensions Ombudsman may award legal costs, but it is the exception rather than the rule. Would it be appropriate to send stage 1 back to the employer if the decision is deemed to be perverse and has not addressed the main point of the complaint? So I would say that under the current set of regulations, it depends on whether the decision at stage 1 was about an original decision that was a discretionary decision or not a discretionary decision. So if it was a discretionary decision, I do think it needs to be referred back, but I would say to the original decision maker rather than to the stage 1 adjudicator. If it's not a discretionary decision, then my view is that the stage 2 decision maker ought to effectively remake that decision, even if the stage 1 person has not properly addressed it. I do think that if for some reason the stage 1 adjudicator hasn't addressed it at all, and the complaint has not yet been decided upon at stage 2, then it may be possible to refer it back to stage 1 for them to deal with it, but you may need the complainant's permission on that. Okay. We are, I'm afraid, running out of time to answer all the questions. There are lots of questions being asked. Yeah, I think we've unfortunately run out of time to cover all the questions. We said 45 minutes for this, so I'm sorry that I've not been able to address all the questions, but hopefully that's been helpful. If you'd like some further advice or help, please do come back to me. So you've got our generic details up there, but my details are douglas.mullen@anthonycollins.com. My telephone number is 0121 212 7432, or if you haven't got a pen handy and you forget those details, then you can reach us through our website, anthonycollins.com. Well, thank you very much for joining us. We do hope that's been helpful. If you've questions that haven't been addressed and you would still like addressing, then please do get back in touch and we'll do our best to address those.